Hello, everyone, and welcome to Environmental Justice Litigation Part 3, looking forward to advance environmental justice through the courts. My name is Chandler Randall, and I'm the Manager of Educational Programs here at the Environmental Law Institute, and I am so delighted to welcome everyone to today's webinar. ELI is proud to offer programming on cutting-edge issues in environmental law and policy, and it really is such an honor to have you join us today for this special program. I would also like to especially thank this webinar series co-sponsor, Latham & Watkins, for making this series possible. At the end of today's webinar, we will have time for a Q&A session, so please submit your questions through Zoom's question box, and please do not wait until the end. Please send us your questions as soon as you think of them. I would like to also thank our outstanding panelists for joining us today to lend their expertise to this webinar. And while they will be introduced very briefly, the full speaker bios are posted on our website, eli.org, and I strongly encourage you to check out their full bios in more detail there. As we begin, I would like to very briefly introduce today's panel. Moderating today's program, we have Robin Holsheiser. Robin is a partner at Latham & Watkins, and she is a trial attorney with more than 25 years of experience litigating complex commercial and environmental matters. She is a member of Latham's environmental, social, and governance practice, focusing on greenwashing claims and environmental justice litigation. Also joining us is Scott Badnock. Scott is a visiting attorney at the Environmental Law Institute, and Mr. Badnock has dedicated his career to the realignment of society and nature. He's been a founder of environmental startups, counsel for large-scale brownfield transactions and remediation projects domestically and abroad, a writer of environmental legislation and legal texts, a consultant and advisor for international human rights organizations, and pro bono support for the Flint class action lawsuits, and much more. Taylor Lilly is an environmental justice staff attorney at Chesapeake Bay Foundation. Taylor works to develop litigation to address disproportionate environmental impacts on vulnerable and marginalized communities. As part of this, Taylor works with departments across CBF to develop relationships with community leaders and grassroots organizations throughout the watershed. And last but certainly not least, we have Vincent Martin. Vincent is an environmental justice coordinator at Human Synergy Works. With that, I will turn things over to our amazing moderator, Robin Holsheiser. Thank you all so much.
Thank you, Chandler. And you're right, we have an amazing panel. We got to do a prep session and I was giddy with how much great knowledge you're gonna get from this group of panelists. And I wanna echo one thing. You know, the last two sessions that we've had in this three-part series have been phenomenal, but the best part was all your questions that come in. So if you have them while we're talking, we'd love to see them in the chat box so we can address them as we go. But, you know, otherwise, I just want to get started because what you really want to hear from are these three experts. But one of the most delightful things I heard when we were in our prep session was Scott's excitement and Vincent's about the era that we're now finally in. You know, Scott and Vincent have been doing this environmental justice, you know, hard work, groundbreaking work for, 20 plus years. And, you know, what I've heard from, Scott and others is we're finally turning a corner and there's hope out there, right, Scott?
Absolutely. I would say that there is absolutely a turning point, but what's most important is that the turning point has led us to the beginning and not the end of EJ. This is just the beginning, but boy, is it exciting to be here, that we're finally seeing state courts, federal courts, state agencies, governors, et cetera, finally recognizing how important environmental justice is and tribal consultation issues. And we're seeing that change decisions at every level. Not every time and not in every case, and it's still more rare than it is common, but it's starting to happen. And that is a shift. And it's a very exciting one for EJ advocates and activists everywhere.
Mm-hmm. And I'd say one of the key pillars of EJ's success through litigation is one of the cases that one of our panelists, Taylor Lilly, was directly involved in. And that's the one we want to start off with today. So we're really fortunate to have her here because she can give us that behind the scenes information that was going on in Friends of Buckingham versus Virginia State Air Pollution Control Board. And that's a Fourth Circuit opinion. So Taylor, why don't you tell us a bit about that?
Sure. So the case is Friends of Buckingham versus State Air Pollution Control Board, but CBF was also actually a plaintiff in that case. And I joined CBF right before the case was going to oral argument before the Fourth Circuit. And one of my first weeks at CBF, I went out to a rally in Buckingham, Virginia, and that was sort of my training ground to learn what the case is about and what it meant to the community. So the Atlantic Coast Pipeline proposed a compressor station, which is what helps move gas along a pipeline in Buckingham County, Virginia. It was originally founded by freedmen, Buckingham County, and still is home to many of the descendants of those who founded the area. And when it was proposed by ACP, the permit went to the State Air Pollution Control Board. And Virginia has really interesting regulations called site suitability regulations. And they've got some good stuff in there, but one of the things that the case focused on were the Air Board's requirement to consider the suitability of the site for the proposed project and also the character and degree of injury to the community. And as support for whether or not that site was suitable, the community submitted a plethora of information specifically about the community's demographics, its makeup, its history, and CBF and others also submitted expert reports about what the potential emissions from that compressor station, how they would impact the community. And all of that information was submitted to the Air Board, and they chose instead of looking at that information to adopt the findings of the Department of Environmental Quality, which said there's no EJ community here, there are no impacts, don't worry about it. And so CBF and SCLC, representing the Chesapeake Bay Foundation and its members, and the Friends of Buckingham appealed the decision up to the Fourth Circuit. It went to the Fourth Circuit because ACP had a permit from FERC under the Natural Gas Act, and so we went directly up to federal court. And at court, we got one of what has become to be a seminal ruling in the environmental justice cases. Very famously, Judge Thacker said, environmental justice is not a box to be checked, and that has lived on beyond Buckingham and has been carried through not just in the legal context, but also in the community advocacy context. Lots of folks have adopted Friends of Buckingham as their mantra, their rallying cry for increased advocacy and increased attention in EJ communities across the watershed, across the nation, and maybe even a little bit internationally, who knows? So there's been a lot of scholarship around it. But really importantly, the court found that you can't use these broad standards to evaluate communities. So EJ Screen was a tool that was used to determine whether or not there was community of color. That was inaccurate based on the ground data. They looked to national ambient air quality standards, really broad Clean Air Act standards to say the air is clean here. The court found not a sufficiently searching analysis of impacts in an EJ community. And those lessons have been carried through down from the Fourth Circuit and now through the Virginia legislature, throughout Maryland and Pennsylvania, and also again across the nation, because granular data and granular review of communities is what gets you answers about how a community will be impacted. And so that's a very broad overview of Buckingham. And I think a lot of other cases have picked it up and broadened its scope a little bit.
That's terrific. Vincent, have you seen it play out just, in the work that you're doing?
Well, I see. I wear a lot of hats in what I do because I represent communities with the government agency, and also I'm a member of Citizen Science, where we're incorporated, try to get because I'm trying to find help and solutions. Because whenever we can get from conversations to solutions, when we are winning. Basically, and my main concern, what I'm researching right now is on PM 2.5 and PM 10 matter. Because I am really concerned by a lot of the research that I'm receiving is that these nanoparticles that are in the air coming from all these exhaust pipes and you name it, are actually, we're breathing in and get into our system. Once it goes into our system and goes to our bloodstream, it starts attacking our vital organs, start making our body insulin resistant. So we are actually creating our own type 2 diabetes because our insulin is not sufficient enough to help us burn the body fat and process the fluid in our system. So now we have to go outside and get outside insulin. And basically it is a revolving cycle that continues on. And once you get on that wheel, you don't get off. And most areas that are affected are usually hospital deserts, food deserts. I mean, because these are impoverished communities that are mostly affected by these issues. So I'm really glad to see that we're, like you just mentioned, all those screening tools. I've been an advisor on a lot of those screening tools. I'm glad to see them finally coming out because they've been sitting shelved for a long time. and I was really upset when they was wanting to take the EJ 48 issues, how they were going to take using race as a criteria. And I'm saying, wait a minute, all the laws have race as a criteria. Now you're going to turn, when it comes to funding, you always want to omit race out the picture, causing another disparity. So I'm so glad now that we're finally getting some guidance, and we need community at the table, because if we're not at the table, we're going to be on the menu.
That's absolutely right. And Scott, how have you seen that Friends of Buckingham play out? Because as Vincent says, we're thrilled that now you've got the courts kind of backing that you can't just check a box. You really need to use your screening tools and really, be enough, focus on it.
Well, while it's not, a Supreme Court ruling or a piece of federal legislation, the ripple effects have been very significant, because you're seeing at the state level that there's a recognition that if federal courts are going to start, insisting on very substantive EJ efforts in decision making, including mitigating risks, eliminating risks, and engaging with the community throughout, then states are going to have to respond at some point or another. And a lot of states have affirmatively taken up that mantle, as you know, California, New Jersey, New York, et cetera. And they're really they're not going to let Friends of Buckingham force them, because they're ahead of it. Now, they still have a long way to go too. And there are plenty of courts that are going to resist, and there are plenty of states that are going to resist. So Friends of Buckingham isn't a panacea, but it is absolutely a major turning point when the Fourth Circuit essentially says no because of EJ concerns, right? That was huge. So I'm seeing overall the substance of EJ engagement improving, and I'm seeing the commitment to the public policy, the public participation aspects of EJ really firm up as well. That agencies at many levels are recognizing that when you're affirmatively working with communities and they are engaged as partners, that things go much better, and that corporations are realizing the same thing, that when you can be proactive and you can be affirmative about your approach to these communities' issues, and you engage with them in good faith, suddenly you can have very good results. Your project gets affirmed, your permit gets affirmed, you're on time, you're on budget, there's no protests, there's no lawsuits, there's no boycotts, right? It's better lawyering. And so I am seeing this shift in both of those directions, where agencies are starting to firm these things up and make them more substantive, and corporations are starting to take more affirmative steps to do it the right way. Now, to Vincent's point, it has a long way to go. The saturation, we just got to the surface, and we still have to get all the way down to the bottom. But the tides have turned, right? And so we just have to keep pushing. Of course, there will be backlash and some retrenchment, but I think that Friends of Buckingham was a major turning point for EJ. We've had our big day in federal court, and it's, these sort of EJ laws are now standing firm. And I'll just say on that front, California's EJ laws that have been built over now 20 years are finally showing that they are robust and that they are holding, and that the requirements the state has made towards agencies respecting EJ communities and tribal communities in their process, and not just hearing them out, actually taking action towards those issues. It's starting to really happen. And I know, I practice in California, so I'm biased, but I know other states in New Jersey, New York would fight with me on this, but they are really establishing meaningful substantive laws here. And I think that Friends of Buckingham is one of those points that really pushes that further forward.
And Taylor, has the Chesapeake Bay Foundation or other, organizations utilize the Friends of Buckingham decision, going forward in the ways that they're, trying to attack EJ problems?
Absolutely. So a lot of EJ issues, a lot of EJ advocacy starts at the state and local level. So when a permit is first announced, and in submitting comments on proposed projects, we cite to Buckingham every single time to say this is what the Fourth Circuit has said it means to do environmental justice. We were just before the Virginia State Air Pollution Control Board, the same board that was at issue in Buckingham at the end of last year on Mountain Valley Pipeline's compressor station that was being proposed. And once again, Buckingham was a center point. And when MVP made the decision to appeal that eventual denial that was based on the Friends of Buckingham decision, they cited in announcing their issues to the Court of Appeal, to the Fourth Circuit, Friends of Buckingham. And so it's a dual-edged sword, because yes, we are using it. We're using it proactively. I live with the Friends of Buckingham case site on day to day, but other folks are seeing it too. We're seeing industry pick it up, seeing it cited in footnotes and industry applications and brought up. And so Buckingham is now a pretty constant source in my life, and it's also become a colloquial word for doing environmental justice in the Bay region with communities I work with.
Very interesting. You know, I want to, before we move on to some of our other topics for today, I would love to consider a couple of other cases that came out in 2021 and focused not so much on the state law requirements, which was the focus of Chesapeake Bay and the fact that those hadn't been fully considered, but on NEPA environmental rules, you know, the federal standards that are in the NEPA analysis that are conducted by federal agencies. And I know the two cases that we were going to discuss today, you know, one of them provided a victory of sorts for the EJ community and the other not. Scott, do you want to talk about some of those that I'm...
Yeah, you know, it's just, I mean, the DC Circuit case, the Vecinos para Bienestar in 2021, you know, that case established, you know, it was very similar in that it shut out a polluting facility under NEPA grounds, but also that really specifically zoning in on that the impact to the local low-income communities was significant and real and needed to be addressed. So that was another circuit court doing something great. Yeah, I'll drop the citation in right now. But the second case was what I had mentioned earlier, which is the Fifth Circuit, which is a particularly rough circuit right now. Although I will give a shout out to the Fourth Circuit being a place that no one thought when I was in law school would be a favorable place for environmentalism, and now has become. So courts change, they shift, their makeup changes, worth noting. But the Rollerson case, which I'll drop in the citation as well, that was basically more of the same. And what I mean by that is the attenuation, an extension of the original policy of erasure. Let's be honest, the typical model for governments and corporations is to erase the EJ communities and their concerns entirely. Now, they can't actually do it in real life, but they do it in their planning and then the way they talk and then the permits they submit. In other words, they'll say, in a case I was recently on that we won for EJ purposes, the corporation for 22 years contended that there were no EJ communities affected by this project. And despite 22 years of evidence that there were, including EJ screen at the federal level and at the California level, they never wanted to admit that. But that has been the common method, erasure. You don't even exist, Vincent. You know, and this is what's finally, I think, changing in other courts. But Rollerson, and of course it's the Fifth Circuit, doubled down on this old erasure model.
Mm-hmm. So we're seeing it both ways. You know, Taylor, I don't know if you noted, we had a question in the chat that wanted to know a little bit more about the specific language of the Virginia code that was utilized in Friends of Buckingham. And what were the concerns of that statutory interpretation? What is it that they didn't do? And, you know, do you think the outcome would have differed in Virginia State Appellate Court versus the Fourth Circuit? A very good question.
Sure. So Section 10.1-1307E of the Virginia Code lays out the site suitability regulations, and it says that the board, in considering air permits and approvals, must consider these factors, and it lays out factors A through E. And that those particular factors, and whether or not the board had thoroughly considered its duty under those factors, was what was at issue in Buckingham. But it was two-pronged because we were working under a state statute, but the issue in question was environmental justice writ large. And so the court was interpreting the air board's duty, but also interpreting the concept of environmental justice at the same time. And so there's a lot of really good intro language in Buckingham as well about what EJ is and what we've known it to be, and whether or not what the board did met those requirements. And really importantly, the Department of Environmental Quality, who's tasked with granting the permit and who had gone before the board, had agreed that they were required to do an EJ analysis. And so that question was not issue. And that also allowed the court to talk about whether or not EJ had been done properly, since we weren't arguing about whether or not it was necessary in the first place. That was agreed upon by everyone. And so it was an issue of state law. Very interestingly, that law was recently revised in the 2022 general session. So what we knew section 10.1 to be is not what it is today, or not what it will be by the end of July, but it was what was at issue in that particular case. And even though that is sometimes used to say Buckingham applies in this one particular context, one of the other things I think is important to note that the court had a plethora of information to consider because of the amount of legal, scientific, and community support that was lended to Friends of Buckingham. So they were able to consider granular studies, door-to-door knocking studies that anthropologists had done for free just to support the community. They were able to consider PM 2.5 reports, like Vincent was saying, that CBF and SELC submitted as expert reports. They were able to consider a lot of data. And so you might not be able to recreate the code, but it is possible to recreate the support that the community received and that the court eventually got to consider.
And that's a good point. So we have the two decisions coming out favorably for EJ concerns, and then one not so favorably out of the Fifth Circuit. It kind of seems to highlight that the one thing you can't do when you're trying to write an injustice is put all your eggs in that litigation basket. You know, my panelists, what do you feel about that? And what are some of the ways we, address that fact?
Vincent?
Yeah, well, one of the things I'm looking at right now basically is Title VI, which is supposed to be the protection arm of these environmental laws, where we're supposed to be able to go and file the complaints and those issues. But we're running into a problem where staffing at EPA is not sufficient. Basically, we're always, because the administrations change, we're always in a state where we're retraining the new staff on this. So we're always caught in this wheel of, and time steady is moving. People are steady getting harmed, and it's a big issue. And dealing with attorneys, say like here in Detroit area, we got this, I'm surrounded by 42 heavy, major and minor industries. And we've been fighting, trying to get cumulative impact study done for now 20 plus years. And they always tell us, no, it's gonna be too expensive. It's always, but then when something happens to another community that don't look like mine, they get all the resources, they get movement. I mean, just for instance, what happened to Flint? Flint got a resolution, but it was not good. I mean, they end up getting I measured out, and they had me sitting on that panel on the group representing the community, and I was upset because I said, "Why you don't have no one from Flint here at this table?" Because they always try to go, and I guess they thought I was going to be the point of least resistance, but I was very dissatisfied with $600 million. It sounds like a big figure, but when you divide it up by 2,000, 3,000 people, it comes out to about $400. And these are people that are going to be affected by lead poisoning and different kind of issues. This is going to be lifelong illnesses that they're going to just sit down and guess what? They're still not fixed. They still have water issues. So we keep putting Band-Aids on ulcers. We need to fix the problems. More solution-based problems is the answer.
I agree with that, Vincent. And what I call this is Pyrrhic victories, right? That, they're victories in name only. And, I was humbled and honored to do pro bono on the Flint case. And, it is horrific to me that this is the result. A few $1,000 for getting your life poisoned and your children poisoned, children that went from high achievers to can't learn in school. This is just tragic. And so what I really want to focus on, and this is why, EJ litigation, I got a little secret here. I don't think EJ litigation is a great route most of the time, even now. And the Flint case is lesson number one. Okay, that took years and years and years, and a few $1,000 ain't going to cut it. It's nowhere near the solutions they needed. Now they're working on it, and I will give the people in the state of Michigan who are working towards solutions a lot of credit. They are, and that was a huge problem. I mean, that wasn't a little bit toxic, folks. Those were thousands of times more toxic than the legal limits of lead and all kinds of other stuff. Okay, it was horrifically toxic. And it went on for far too long. But the point is, and I've been trying to, combine with my first comment, which is we're finally getting EJ laws, tribal consultation laws, and policies at every agency level around this stuff. Okay, what does that mean? More lawsuits? I hope not. That's not, okay, sometimes if you're people like Taylor and you have a group of attorneys who get that winning a certain case in a certain venue can yield very significant results, those are the people to do that. But from a community level, most of the time, what you should be seeking is non-litigation avenues. And those are opening up more than ever as a result of what I said at the beginning. And so I just want to say that the things that you can do to represent communities in front of and in partnership with agencies that now want to work with you, that's the lawyering that's needed. So you can help represent those communities through emails, phone calls, live meetings, public participation events, relationship building, coalition building, long-term goals with short-term wins along the way. These are the types of administrative and agency level advocacy that when it's coupled with the activism that the EJ communities are often already engaged with, letter writing campaigns, letters to the editor, public protests, et cetera, to raise awareness and pressure, suddenly you can get changes at the agency level and at the corporate level, because the agencies can give a very forceful nudge to certain corporate actors to say, hey, just do it this way, okay? And so this engagement with all these agencies and voluntarily with the corporations who maybe have a facility that's polluting in your neighborhood or are interested in putting a new facility in, engage with them. And believe it or not, a number of these groups are starting to see, because of things like Friends of Buckingham, that they better do it affirmatively and then on the front end. For the lawyers out here who've done this sort of stuff, it's kind of like preemptive steps, right? Instead of you've lost a case and you owe a community a bunch of money, and yeah, it still doesn't solve their problem. It's a Pyrrhic victory for them, but it's still a bunch of money for your corporation. Do you really want to keep going down that route? Or do we want to instead preemptively work with those communities, address their issues, have them on board, have them thrilled, have the municipality and the city thrilled, get the project done, right? You see my point? This is what is happening now. And it's beautiful. Before, we used to have to throw rocks at the door and they'd like listen out a window and then shut it. Okay. Now they're actually coming into the front and say, come on in. We got scones and coffee. Like, let's do this. Right. And that's the different engagement. And so when I want to see lawyers who are saying, oh, EJ litigation is happening, don't think litigation first. It's a tool in your toolbox, but particularly when it comes from a community standpoint of what they need, the remedies that they really need, litigation is rarely that path. Now, it shouldn't be discarded simply because it's hard. It can be a great tool to increase leverage, especially if you, for instance, work with a coalition that includes lawyers, like Taylor's group, who would come in and add real legal heft to a particular thing. Then a corporation and agency say, oh my goodness, they could actually sue us. And maybe they'd actually win. Maybe we should just do this instead, right? That's how you can use litigation to effectuate better results. But ultimately, there are better ways to achieve things for communities than just seeking litigation. Taylor, what do you think about that?
I have to say, I tend to agree. Which I think what probably sounds a little weird coming from me with my title, which is just environmental justice litigation. But as an environmental justice litigator, I'm also a community lawyer. And what that means is that I have to lawyer in a different way than I think we traditionally would expect when you go into the legal profession. And that means being really transparent about what you can expect from litigation as an avenue and whether or not it's the right avenue for you. We sometimes refer to litigation as the absolute last resort. When you feel like there's nowhere else to go and nothing else you can get, maybe you want to try litigating, but there are other paths to go on. And that's also why it's great to be at a place like CBF and to be in an area like this watershed where there's so much grassroots activism, because sometimes I'll meet with the community, listen to them and hear what they have to say. And the answer is something, but it's not litigation. So it might be building partnerships at the state government level. It might be getting grants to support funding. It might be a cancer research study because you've got 9 Superfund sites in a 15-mile radius. Litigation is not always the answer. It is an answer, but it doesn't always have to be the answer. And so while I'm overjoyed that litigation remains an option for communities, I think it's important to remember that it's just that, an option, and that it's important that as much as we develop litigation as an avenue, we develop all of the other options too, so that the only recourse you have isn't through the courts. Because I think we all watch the courts a little bit more closely now than we used to with how much they're televised, and we've seen how diverse these outcomes can be for good or bad. And that's important for communities to know and for us to learn in terms of what we recommend and how we look to support communities who are experiencing environmental injustices.
And may I interject something that could be very helpful for communities also? Most of this information that is given out regarding environmental is so technical. How can we get it written down that the ordinary person can understand? Because usually we're speaking, the average reader is reading at a 3rd grade level, but we write these documents at you have to be a grad student just to be able to understand it. So that's an issue. And we got to get these industries from self-reporting. Those are 2 things that's paramount that will help community, because emissions are being reported by the same industries, and they always lowball the emissions. So we don't know if we're getting the right information or not. So I yield on that. Thank you.
Oh, Robin, that kind of segues nicely to greenwashing. You're still muted.
Yeah, sorry, I'm really bad at checking that box. It really does segue well to greenwashing, which we were talking about right before everybody entered the program today. When the government is demanding more and more from various industry to get out there and talk about what they're doing when it comes to environmental, social, and governance issues. And you've got shareholders and you've got activists that are forcing larger corporations to do and say or create policies and then actually act on them. But what we're finding is that a lot of these various organizations are also being accused of greenwashing, and by that means that they're promoting their company as having a policy or a practice that others believe it is not. Or that they're overselling what they're planning to do or have done in the EJ space or in other environmental and social governance issues. What have our panelists seen out there in the real life? Are they facing that? And some of that's getting addressed through court and litigation, but I'm sure there's other avenues like you're talking about. But I'm interested in hearing what you have to say about the greenwashing that's been going on.
Yeah, well, I'll say it has been more common than not in terms of outcomes versus claims. But I think it's really critical that corporations and their attorneys remember that your reputation is more valuable than money. Okay. Everybody keeps seeing is like, oh, we're gonna have a bad judgment, but it's only 600 million and we earned 5 billion from that thing, so it's not that big of a deal. And it's always getting into the money. Instead, reputation and goodwill, that's the most valuable thing a corporation has. And when greenwashing claims come out and you're exposed for intentionally or not failing in these greenwashing ways, you're taking hits. The public is sending the notes around. The boycotts happen, the protests happen, the tweets happen. This is bad business. So greenwashing you may have gotten away with it in the past, but it's really difficult to fudge that stuff. And with so many eyes and so many people reporting and looking, it's just going to be difficult. So what I'd like to sum up here is, this is a form of bad faith lawyering that, you know, has frankly been a scourge in our profession. Bad faith lawyering is bad lawyering. When you tell a company that greenwashing something is okay, you're being a bad lawyer. Not only is it unprofessional and unethical, but it's going to bite that client in the you know what. And that's going to be a problem for you. Good faith lawyering, on the other hand, is good lawyering. That's this Ben Wilson model where you go into you know, a corporate setting as the representative, as the attorney, and you say, no, corporation, I think it's much better if you do this, and you address these concerns of the issue of the community, invite them in. Let's have these talks. Let's do it the right way. Oh, there's a claim that may be fudged a little bit, but maybe it's okay because our accounting practices. No. We're not doing that. We're going to actually do what we say. And that's going to be better lawyering, and that's going to have a better experience for your client, less boycotts, less lawsuits, less bad reputation, right? But I also want to just address Vincent's point, which is that environmental protection has historically been strictly a quantitative assessment, right? How many parts per million of XYZ is enough poison for a human to deal with? That is not okay. The qualitative aspect of environmental protection has largely been left out. And what does qualitative mean now? The actual experience, the lived experience of the humans who live there, right? So the environmental protection regime has been almost strictly quantitative throughout its history in America. It's now starting to get more qualitative, even though I would posit the original act of NEPA is very much including the quality of life in its language, but the courts denigrated that year after year. But environmental justice is what is reinvigorating the qualitative understanding in our environmental protection regime, the quality of life. Flint's a perfect example. The regulators said, oh, parts per million are fine, they're in here, I don't care what they're saying, it's just fine. The lived experience was, this is brown water, it's out of my tap, it's disgusting, it smells bad, I can't wash in it. Administrators went back to but the data guy says it's great, says it's fine, right? This is why, because fundamentally, the environmental protection regime has been strictly in quantitative. It didn't care about the qualitative. It erased the qualitative. Now, environmental justice is saying you can't erase that. Friends of Buckingham is saying you can't erase that. These people exist, they have rights, and guess what? A bunch of our laws, even in some red states, are not just hortatory language. This is, you said that all people have to be cared for in the same regard in terms of environment, in terms of health, in terms of access to water, and you're not doing that. You need to do that now, right? So this is the quest for environmental justice. It's to reinfuse the quality of life into our environmental protection regime and balance that back out.
We have a question in the chat box that I think is a bit of a follow-up on this, because it's talking about the kind of data and you know, I'm not sure, I'm sure Taylor, your organization has done some of this litigation too, but they wondered whether you've seen successful litigants use the Civil Rights Act with EJ in the courts. And if so, you know, how did they succeed? And then how did they use this data that we've been talking about if disparate impact is alleged?
So, and this is not to say that it's not out there. I haven't seen a lot of it in the courts, but one example that has been really popular in my region is in Brandywine, Maryland. So the community there filed a Title VI complaint with the EPA after Maryland's Public Service Commission approved a permit for a facility in Brandywine, which is overburdened. And they did that because the PSC receives federal funding from the EPA, so they're able to file a Title VI complaint with the EPA. And they said, this decision runs afoul of environmental justice. It runs afoul of the Civil Rights Act because of the impact to communities. And that complaint could have made it up to court. I think it eventually made it into settlement conversations, but that has become one of the success stories that we hear a lot, of being able to use Title VI and the Civil Rights Act in particular to talk about EJ. And I think one of the more famous ones is also actually out in California, where Scott is, after the EPA had made a decision to spray a bunch of pesticides in a predominantly Latino community and tried to back that up, and a Title VI complaint was filed. And for the longest, Title VI complaints have languished in the EPA's office. And that complaint in California is one of the ones that is held up as, this is the one time it made it through, and it has really big implications for the way that we consider it. And so it's out there. And then in terms of data on disparate impact, we live in the data game. That is what we do a lot, because we see a lot of things, and particularly in Friends of Buckingham, ACP said, well, they're going to be breathing cleaner air than the rest of Virginia. They're breathing cleaner air than Virginia Beach. They're breathing cleaner air than Richmond. Why should we care about the PM 2.5 impacts from NACS? And so that's the way the disproportionate impact game gets changed, because we weren't talking about communities breathing the generalized air of the Buckingham County. We were talking about people who are going to be living in the path of the compressor station, who are going to be living 200 feet away from the compressor station. What they breathe and the particulates that they breathe in does not amount to what the general national ambient air quality standards are for community. And you can't point to those to say there's no disparate impact here. And so data has been a two-way street for us, like so many other things that we talk about in this panel. Good data is how we clarify a picture of a community, but we've also seen applicants use data to muddy the waters and say that there is nothing to see here. There is no picture here. They're just trying to do subterfuge. And so community science, a lot of experts who have been looking at air monitoring data, a lot of water quality data, all of that information is important to clarify what the impact is and what it means to be determined to say that there is a disproportionate impact.
Hey, Taylor, and the word you're looking for is fence line communities, the ones that share the border with these industries that are getting affected by, all these pollutants, and the ones that are the closest, when it rains, it falls right on top of them. So, I mean, because, we got to remember, pollution has no borders. It travels great distances, and it affects everyone differently. We just cannot, and these one fix for everybody is not the solution. We need to take every individual and see exactly what are going on, because what affected my community could be completely different, because I might have a lot of people with asthma problems, so they get the breathing restrictions, where other people might have other things that might be affecting, because the growing industry in our communities now are dialysis clinics, and that's a sad state, where a place where we got all these different laws and acts, and the biggest problem is our government is granting these permits in these communities and not really looking at the mandates from those acts. That's a real issue that we need to concentrate on. I yield.
I will say sacrifice zones continue. There's no doubt about it. And that is the energy. And so, yeah, like, for instance, I just stopped this one polluting facility, but it's in a neighborhood called the Toxic Triangle for a reason, right? It's because it's already highly, highly toxic. I'm glad we got to keep one out, but it's nowhere near the solution. We've got a long way to go. In terms of civil rights, I'll just say a couple things. One, Title VI is not good enough. Big shout out to Marianne Engelman-Lotto and all the folks and I put the link in the chat, that won the case to force EPA to finally start acting on these Title VI. But even at Title VI at its finest is not enough, because ultimately it just makes communities a petitioner, meaning, hey, EPA, will you please do something like we think you should, but it doesn't give you any really legal rights to pursue that beyond that petitioner status. So Title VI gets a lot of the noise around civil rights with EJ. I think we need to start looking at other things, including how do we make substantive civil rights gains, right? Not just procedural. Much of the focus of EJ has been on procedural stuff, but something that was included in, and I'm just going to throw the link in there, into the Flint case. I won't go into how everything shifted, but there's the Ku Klux Klan Act, the Civil Rights Act of 1871, right? This act is very real, and yet courts, time and time again, especially through a bill that I have fought through the American Bar Association, which is Middlesex v. Sea Clambers, a Supreme Court case that said, hey, things like the Ku Klux Klan Act, you don't get to touch those if it's an environmental issue, because there's environmental laws and you need to stay in there, right? So they have foreclosed this Middlesex v. Sea Clambers law, holding, has foreclosed communities' ability to use civil rights and constitutional law principles to access damages for environmental destruction because a Clean Water Act exists or a Safe Drinking Water Act exists, and so you have to figure out your remedies in there. But there are no compensatory damages, as most of us know, in those seminal laws. And so the best you can do is injunctive relief, right? That's not enough. That's not enough. So ultimately, we need to crack open our constitutional law and our civil rights law to start achieving more environmental justice, substantive environmental justice results. And I think smart lawyers are doing that and are investigating how to do that. But also legislation could be passed, and the American Bar Association passed a policy that I drafted saying that Congress needs to overturn this Middlesex v. Sea Clambers Supreme Court ruling from Justice Powell, the Chamber of Commerce justice, imagine what side he's on, so that communities do not have remedy dead ends within our Clean Water Act and our et cetera, and in fact can tap into these much more important principles. I'm an environmental guy. I think environment's pretty much as important as it gets. And I can agree that constitutional and civil rights principles are above those and should not be precluded or preempted in a court setting just because environmental laws exist. So just, great question about civil rights, sort of involvement.
Another thing we've spent a lot of time talking about is the data and how important it is and the various tools. You had mentioned during prep session the importance of citizen science and making sure everything is data driven. Where have you seen the greatest kind of advancements in that area?
Vincent, you want to speak to that?
Yeah, well, the greatest advancement that we're doing in that area is talking about the data extraction that academia, industries, government does from community. And they sit around here and how they get our data, and they, and they make, a lot of them get tenure, a lot of the professors get tenures, they pay their staff, and you look down the road, the community is no better off than when they get there. So that's something that we definitely talk about, and we talk about the ethics on how they use the data. Those are the things that we're sitting down. I mean, we just signed an MOU with citizen science on how we're going to work with environmental justice. We're trying to create a template. This is something that me and Omega created on how we start having communities working with these outside entities that come saying they're going to come help, but all they actually is coming to gather data and leave, and then they monetize the data and don't give nothing back. So how can we, resolve that is the big question, and that's what we're working on right now with citizen science. And I think we made leaps and bounds, but we still got a long way to go. We just finished our third conference. We did a virtual conference just last week, and that's one of the main issues that we're talking about. How can we put the neighbor back into the hood to make it a neighborhood? I yield.
So I'll just say, I also dropped in the chat, ELI has a very robust citizen science program. Not all citizen science is created equal, okay? Really understand, folks, if you're going to embark on that, or if you're going to encourage a community to go down that route, which has been incredibly effective in certain instances, particularly Dr. Hannah Mona Atisha and everybody who developed data around that, bless them. That was what validated the lived experience of the folks in Flint. That's how they come together to effectuate change. Citizen science is a game changer for EJ. Those are things, attaining that level of data are things that we used to pay 10 years ago, 6 figures, really. And now there are apps for that, okay? So there's really an amazing shift, the democratization of tech in terms of acquiring citizen science. But as a community and as a representative, you need to first think about what is the exact data, in what form you need to prove whatever you're trying to prove, and work backwards from there, rather than let's just gather a bunch of data and hope it's helpful. right? So I put in the best practices guide that we published, I guess, God, it was 2 years ago now. It feels like it just happened, but I think it's still on point, and I'd love everyone to take a look at it. But facilitating, as a representative of a community, facilitating their positive use of citizen science is now a critical and powerful tool that we all have, and it creates tremendous leverage, which is ultimately what EJ communities need the most, what they've lacked the most in engaging with these disparate parties, right, is leverage. And when you have a ream of data that's to scientific standards, it's hard to refute, really hard to refute. So that's the beauty of citizen science. And again, that goes to the first thing I said and why it's really an exciting era for EJ lawyers and EJ communities to finally start achieving real results.
Hey, Scott, and also it's hard to refute when you have industries coming up with their numbers and you can come up with your numbers that show the difference. It makes a big, big difference because
That's really
a lot
right.
of times, and our regulators usually go with industry's data because they said, well, the way that you picked up the data, I said, well, we did it just like you do it. I mean, because we've been trained by scientists to collect this data. See, because they try to say, well, you don't have the know-how and expertise. But when you're working with these scientists, you develop the expertise and you start, being able to fend for your own community.
Absolutely right. Absolutely right.
And Scott, did you see in the chat, we had a question about, shifting a bit from our quantitative to our qualitative kind of, standards or data. How do we go about that? In the chat box, how do we create that standard? Because otherwise you've got otherwise it almost looks like it's in the discretion of the courts or EPA, which traditionally has not favored our EJ,
Great question. It's a great question. And I believe the solution is, as I discussed earlier, but just to reiterate, that these two sides have to come together, that you have to use the quantitative to inform the qualitative and vice versa. And one should not rule out the other, right? So when there's a bunch of data that says, no, it's fine, it's not poisoning them, but then there's, I call it data. I would call a jug of orange water from Flint. That's data too, right? But we treat that differently. So the combination that's happening, and California has been, I think, particularly innovative about it, is we're going to use, for instance, let's just give an example in terms of defining what a disadvantaged community is, or an EJ community, right? That they'll look at the different quantitative metrics, and they have a bunch of them to determine that. And then if you're in a range, then the community itself, on its own self-determined basis, can communicate with the agency about what it is in terms of its demographics and its challenges. And those administrators can take that qualitative data to add to their quantitative data and then make better, more informed decisions about it, right? So yeah, I mean, life is subjective, and do you like blue better than you like green? That's not the questions here. The questions are, do you like orange water or do you like drinkable water, right? The combination is how we avoid the big failures, right? Now, at the margins, these questions get very difficult, and there is no perfect solution at all. But what I would say the way to get to the best possible solution is through facilitative and good faith negotiations, affirmative efforts to reach those with the agencies where they say, okay, we've dealt with your quantitative issues. Now we've addressed your qualitative issues, and everybody's moving forward in a positive way. It doesn't mean everyone's got exactly what they want, neither the corporation, neither the community, but that they've gotten much closer to a positive result. That's the path ahead, where the qualitative informs the quantitative. It doesn't supplant or remove the quantitative, but they finally work together and have to inform each other.
One of the things we talked about during the prep session was that litigation is, of course, just one of the tools in the tool chest, but that there are other litigation skills that can be brought to this entire issue that you're facing. Think that are not quite, the act of filing that first complaint. Can all of you address, when you're looking at the client's problems that you're helping to address, and without naming names, what kind of litigation skills or litigation techniques are you utilizing sans of, going forward with an actual complaint?
I think so much of environmental justice is a battle of narratives. And I think that what lawyers are in one subspect is storytellers. We're telling a story to the courts of what the issue is. And when you are dealing with a potential environmental justice issue, you usually have two stories. You've got the industry story, which is everything's fine, look away, don't worry about it. This is going to bring so much money. We've got a long history of the community. And then you have the community story, which is we're concerned, we're scared, we've experienced this, we're looking at our orange water, we're looking at our contaminated land, we're looking at our health impacts, and it doesn't seem like this should be here. And so at least when I'm approaching community, when I'm working with the community, what I'm looking for is the story. I'm looking to hear from them what their story is and what it has been, so that when a regulator comes and is going to be considering whether or not a proposed facility is going to end up in a community, they're not just hearing the applicant's story. They hear the community story, they hear their experiences, because so many times the community experience don't get on the record. The applicant has this whole pre-stage where they get to submit expert reports and files, and they work with the agency, and for 6 months they're compiling all this data, and then one day you get a notification that says application is open for public comment, and you've got to look at 400 pages of the industry story and come up with your own and determine where the holes in their story are. And so you're not necessarily at the litigation stage yet, you're not bringing a complaint, but determining what the facts are on the ground, what the agency has to consider, what kind of things that you should be telling them, what kind of things they've been told, all of that fact finding, all of that Sherlock Holmes sleuthing that you don't expect to be doing and preparing for a case, all of that goes to being able to actually engage in this David and Goliath kind of battle that gets set up when these facilities are proposed, to being able to bring your own weight. And that's the qualitative data that I think that gets missed, is what the community is experiencing. We saw a Superfund site say we've got a long history with the community, and we had a community member say, yeah, a toxic history. I remember my father coming home covered in asbestos. That's my long history with this facility. And so those are the kind of ways that you can bring in the legal strength that is not the courts, but is still powerful to bring before regulators and decision makers to turn the odds and sometimes help the odds in your favor and ensure that the industry is not the one who gets to sign off on what is going to happen in a particular community. It's the people who live there and who would live with this facility or with this proposed project or industry if it actually makes it there.
So can I just tag onto that? I think that's brilliantly said. And that's really all about story and winning the story battle. But I think one of the most critical points that I try to make to EJ communities and to their lawyers is find journalists who are interested in that beat and befriend them and communicate with them and work with them. Because frankly, while Taylor's right, we have to win the story battle, lawyers aren't that great at telling a story, okay? The Johnny Cochrans of the world are a rare bunch who can tell a narrative that is compelling, okay? And so lawyers need journalists because journalists know how to tell a story, but journalists also need lawyers because journalists don't understand the law and often are challenged in describing aspects of it, right? So I always tell EJ communities, yeah, find a lawyer, but make sure that lawyer finds a journalist. And those are going to be your best friends. They're going to work together. I'll also just note that both of those professions, journalism and law, face the same risks, which is contempt of court, right? You can actually get thrown in jail for your profession. If you believe that something is unethical that a judge is asking you to do, you might go to jail. If a judge asks you to turn over your sources as a journalist, you protect those, you might go to jail. Right, so there's a long history of journalists and lawyers sort of working together, achieving similar results, but also facing the same downsides and risks. But telling that story is going to be critical. That's how you move the narrative with agencies, and that's how you get corporations to change their tune and start listening and start acting.
Well, what's been most effective in my community, we have developed our own capacity to tell our own story. We're creating our own media presence. we're sitting out here and doing campaigns, or we actually becoming our own lobbyists, going up to our local government and trying to lobby them. Even though that's, because a lot of these corporations are also funding a lot of the campaigns for these politicians. So it's a double-edged sword in that. But if you sit out here and you show them that you know the laws and you know the Clean Air Act, you quote these things that they're violating, and even sometimes you say, this is safe and healthy. Let me contact OSHA and have them come and bother you. Those type of things seems to, but the only reason why we litigate is to mitigate. Because if you don't litigate, usually nothing happens. It just be put on the shelves and moved on. They'll be all right. They'll be all right. So you got to actually, that's why we litigate, to get some kind of action, because most of the time you don't get the action. All you get is more talk, and more talk. I yield.
Yeah, that's litigation as lever, right? I couldn't agree more. It needs to remain a tool that communities have, especially like Taylor was saying, sort of as last resort. Like Vincent was saying, when nobody's moving, everything is stopped up. Sometimes litigation can shove that through, so I think that's really critical to understand. I think that's a very important point that you make, Vincent.
We have another question in the chat that I think is an interesting one. Can we address the legal definition of what, is going to be considered a disadvantaged community?
Well, okay, so I have a lot to say about that. I know everybody does. Leaving race out of this thing is like the craziest. It's illogical. Okay, it's illogical. But I will give a little history lesson, which is in 2005. Under Christine Todd Whitman and the George Bush administration, the language of environmental justice at a federal level changed essentially from Black Lives Matter to All Lives Matter. Okay, but they did it in a little different tone, and it was all races have the right to fair, yada 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 yada. But environmental justice specifically is about the historic abuse of certain communities, right? So it's not just this like, oh, in the future, everyone should have, no. It's about recognizing this burden that these communities have carried for decades and still carry, and then doing something about it, right? So, I think that we are burdened with a Republican Party that doesn't want to face the racial issues in America and doesn't want to talk about them or to them or deal with them. And so we have to pretend that it's not about race. And even though the longitudinal data from Bernice Miller Travis and Charles Lee and the gang over and over and over, even today, shows that it's all about race, we don't get to talk about race because half of the government is uncomfortable with it. Okay. That's really what we're dealing with. And that happened in 2005. And that adopted from, even California does the all races stuff in our language. Okay. So that's just a historic problem. I think that the administration's effort was just clearly recognizing that, just being very real about the fact that we can't do the things that we want to do in this country because half of the country's politics won't allow us to even talk about this stuff. So in order to move forward, we have to give it this term, disadvantaged community, right? And so we'll avoid the race thing, but we'll still get there without the race, right? That's the path that they're trying, and it's difficult and fraught and illogical and silly. It is where we are. And I will say that for the most part, when we've done the analysis, disadvantaged communities are coming out by definition to be what we would call EJ communities. It's not missing the boat there, but it is still ridiculous that we're not able to speak about race, which is the core issue at hand.
Scott, call it what it is. It's systemic racism.
Absolutely. And I'll just, to that point, our American system was established 250 years ago to maintain white supremacy and to maintain power over Black bodies, brown bodies, indigenous bodies. Those systems have not fundamentally changed in 250 years. That's what systemic racism is. And that's still what's driving most of our government decisions. why we're here is because finally some of those government decisions have started to go the right direction in our opinion, rather than always going to the pro-corporate, anti-EJ community result.
It's also worth noting that the CJST puts an extraordinarily high bar on being determined a disadvantaged community. You have to meet the 90th percentile for an environmental impact, and at the same time meet the 65th percentile for the social impacts they're willing to consider, which is education and income. And really, interestingly, the Buckingham County, the community we've been talking about that launched the Friends of Buckingham decision, that launched all of this EJ conversation, does not count as disadvantaged under that tool. And I feel like if that's demonstrative of the way that we're looking at this thing, I feel like that says so much, because that community gave us so much in terms of what it means to look at a community at a granular level and determine what those impacts will be. And it was the impetus for the Buckingham case and for the Fourth Circuit. And now under this new tool, they don't even count. And so many communities don't count. And it's frustrating to see, again, knowing your community, knowing what you're experiencing, knowing what your harms are, and then to pull up a tool or have someone else pull up a tool and say, well, I looked at this, doesn't look like that's what's happening to you, and have to respond to that. How do you respond to the government telling you that you're not disadvantaged? How do you pull together the same weight? And so disadvantaged community is in a lot of EJ definitions: disadvantaged, marginalized, vulnerable, lots of different ways to describe communities. But I think it's important that we never forget that the number one factor driving whether or not you live next to a hazardous facility or any kind of environmental harm still to this day is race. That was the finding in the Toxic Waste and Race Report, and that continues to be true to this day. The NAACP has found that, the EPA has found that in its reporting on environmental justice, and it's frustrating to see that race has been recognized as a fundamental part of environmental justice all the way until it had its day in the federal government's sun and the CESJ2. Now it's too controversial to be a part of the analysis. But whether or not the tool considers that it's being considered, it's being a part of the way that these facilities are proposed and where they're proposed. And so even if it doesn't make its way into CJST, doesn't mean that we stop considering it or that communities stop living with it.
Hey Taylor, there's a quiet giant that's sleeping right now that's coming up. It's called COVID toxic waste. Basically, because COVID, we spend billions and billions of dollars on COVID management, but we have not spent not a dime on how we manage the waste. So basically, it's treated as regular waste. So it's going on a waste stream. And I'm afraid, like in Michigan, we have 8 landfills. 6 of them are in Wayne County, which is the blackest county in the whole state. And all that waste with all that COVID, we create PPEs by the metric tons, gloves by the metric tons, masks.
And the tests, all those tests.
It's crazy. And this is getting dumped in these communities. So when you get something like COVID that comes, SARS, COVID-19, then communities that are always susceptible to be able to get infected by these things the most. So it's not.
And then Vincent, this is where the system, to make your point, this is the systemic racism, because those those landfills were put in the Black neighborhoods decades ago because of race, right? But they're still there now. So the administrators are like, well, we got to put it somewhere, so they didn't make the racist decision to put that landfill there. But the system perpetuates the racism because that's where the dump is. That's where it is now, right?
Yes, absolutely. So we're all on the same team, different places, same team, because we all experience the same problem. And what makes it so bad that I come from an urban community, but my friend Omega Wilson, he comes from a rural community and experiencing the same issue because the common denominator, majority Black. Are you?
And I'll say, in the point of Magali's point is actually that's been disproven. That's incorrect. She's made a point in the comment that it's actually the poor populations of each of these races that are the ones that are affected. But no, empirically, that's precisely wrong. We have shown over decades with longitudinal data that it's not about the income level. That's a secondary tier. The first is, are you non-white? Let's be honest. That's the first question, okay? And that's where all the data has shown. So, this is just the truth of our reality. And now we have to deal with that. And there are a tremendous amount of folks who are in power in various levels, whether you're at a big law firm or big corporation or big agency, that are definitely not in alignment with the old views, and absolutely want to address these issues. And we're seeing every good faith attempt that we can. I really do think that the disadvantaged communities issue is just people trying to solve that challenge despite the realpolitik of it all. But I will also, to Taylor's point, I think the Venn diagram has shrunk in that particular thing, meaning there's less EJ communities that are coming up under that rubric. And this is where my point earlier about we must have the qualitative layer on top of that quantitative to inform it, right? This is where a Taylor would come in and say, hey, this community just fell out of the disadvantage, but how could it possibly because of this and this and this? And suddenly there's an administrator who has the capacity to understand those qualitative layers and overrule a quantitative. For instance, let's just say for like sake of communication, you have to hit a 90% number, but your community falls at 89. Does that mean you're not disadvantaged? That's silly. That's ridiculous, especially if you have another set of indicators that show that sure enough, for instance, you are. Well, it's at that point when an administrator understanding the qualitative aspect can say, oh, no, I get it. Yep, you're right there. You're right with the right, and yes, you qualify, right? So that's how we can solve some of those problems. But a commitment to an only quantitative type of tool like that is more erasure, and it's going to lead to more of those negative results.
Yeah. You know, on the quantitative tool, you know, you mentioned CJust. We have somebody wanting to know in the chat box how we expect the EJ screen data to be utilized in, you know, as a complement to CJust. Anyone have a thought on that?
Yeah, I don't know how the federal government is going to use those two tools together, but I do know that we've seen state regulators take up federal tools at a pretty consistent and increasing rate. The Maryland Public Service Commission, who was at issue in that Title VI complaint, wrote EJ Screen into its operating law. So when an applicant is going to submit an application for a proposed facility before the Maryland PSC, they have to submit an EJ Screen report. And that's why commenting on these tools and the effect of these tools is so important, because they're federal tools. They're for use at a federal level. They might be used to inform Justice 40. They might be used another way, but that doesn't mean that's where they stop. They're publicly accessible, and state regulators and local regulators often have very few resources to be able to pull together that kind of data. And what is at their fingertips? CJust, EJ Screen. And so the way that it's used depends on the regulator, depends on how you're able to respond to it. And so it can sometimes, if you meet all of the shiny boxes in CJust, then it's used to your favor, because now you've got like a big disadvantaged yes in your corner, and you've got a bunch of red labels in EJ Screen. But if you don't fall within those boxes, if you're in the 89th percentile, if you're in the 69th percentile, if we're talking about EJ Screen and we're looking at like that 70th percentile threshold, if you fall just below those, then you're out of luck. And so while those tools are useful, if you look at EJ Screen's limitations page, which we bring up all the time, it says in black and white on EPA's home screen, EJ Screen is meant to be used as a highlighting tool. It is not the end all and be all for the data that is available on the ground about a community, and it's not to be used as such. We use it to say we should take a closer look here. And that's the way that we advocate for regulators to use those tools as well. Sure, look to them, consider them, but they are not the final story on communities. They're not the final quantitative data. You're using publicly available sources, you're not including qualitative data. None of that is in the screen tool. So they're out there for use, but they are for use with a pretty important caveat, and one that has pretty significant impacts for communities.
Hey, Taylor just said something very important. And unfortunately, I'm gonna have to run, but if we could get the government to sit here and put the resources on training communities how to use these tools to implement the data that they need for action, that'd be helpful. Because right now we got to stop this practice of getting people from outside our community deciding what's good for our community. Let the people from the community decide what's good for them. And with that, I bid everybody adieu, and thank you for this conversation. I appreciate it. Looking forward for any other results. If you need me, you know where to find me.
Yeah, thanks so much, Vincent. Vincent has to take off because he's got another panel to be on. That's what happens when you're in high demand. But thanks so much for joining us, Vincent. But we still have Scott and Taylor here. If others have, particular questions that you'd want to address, I think we've finally caught up with those that have been lobbied our way.
I see a good question about how to help EJ communities sort of develop. And this is something that I really work on, and I think is some of the most important work. Not all communities are as advanced as Vincent's and have the capacity that they have. It's amazing, and a lot of communities do. Don't underestimate communities. It's really amazing, in fact, how much capacity like the communities have developed. But when you're at a community level and you've got EJ issues and you have a bunch of sort of loose residents, but you haven't organized, coalition building and formalizing your organization is critical to success. So, establishing an actual nonprofit or a committee within an agency or within something, formalizing it is important. Just a bunch of concerned citizens rarely get anything achieved. So form the institution in some form, and then coordinate your coalition, organize a coalition. And the coalition should be of members of very different demographics. And people, when you're building a coalition, remember, you only have to agree on the thing you're after. You don't have to agree on everything, okay? And that's how coalitions blow up, okay? To build a coalition, you really wanna hyper-focus on the things that you're trying to achieve and find all the different groups that, as disparate as you can, that want to see those things achieved, and you get behind them. So wealthy white landowners can work with EJ groups and can work with people who are strictly concerned with the environment and can work with people who are strictly concerned with the academic aspects or the legal aspects. But those can come together to create a broad and deep coalition that can effectuate change. But that's a relationship building and a structure building that takes time and commitment. So you really want to identify who your strongest leaders are, your most committed leaders, the ones that are lifers. They're never moving from here and they've got these issues and they're going to die fighting them. Like the rest, like those of us who've committed our careers to it. Those are the heads, put them together, help organize them, lead from there, build a coalition of partners one at a time, meticulously. Before you know it, you'll have a coalition of 10 partners and your own organization is solid and set. And now you can go forward with engaging with an agency, engaging with a corporation, filing a lawsuit. These sorts of things become very real. So that's my suggestion on how EJ communities can move forward most powerfully.
I think it's also important for those of us who are really well connected to remember not to be stingy with our resources. We talk a lot about being a resource to communities, and it's important that their access to all the different spaces that go into fighting a particular issue or addressing an issue are not dependent on just the person who's engaged. So CBF has an education department, comms department, policy shops in 3 different states, and a federal office, and 55 years worth of contacts. An EJ community does not have access to those things. What can we do to support them and make them independent? Share the knowledge that we have, share the context that we have, invite them into the spaces that we already occupy and that we know that we can open, so that they can do those things themselves when they want to, when they're ready to, when they're interested in it, and give what we have. We might not have everything to give, but sometimes our partners have more things to give. Sometimes we have other questions to answer. Sometimes, like Scott said, I have some thoughts on the way to engage with the legal system, but our comms department has a lot of thoughts on the way to engage with journalists. How do you get someone, how do you reach out to a journalist? How do you tell a story? And our education department says this is the way that you can get education programs into your neighborhood, because environmental justice kind of makes it difficult for environmentalists to realize that you don't only engage with communities of color when there is an EJ issue. There are other ways to bring communities of color into the environmental movement in ways that they've been left out of it. And so making EJ communities independent is also a factor of not making them dependent on us to have access to the space. It costs us nothing to bring other people into the room and to bring other people to the table and to share resources. If anything, it helps us build those coalitions that Scott talked about when we go before the state legislature, when we go before the federal policy shops, to say, we know the stories that are out there. These are our partners. This is who you should hear from. And then we can step back, because it's really easy for big green to take up space, but it's much harder for us to step back and say someone else should tell the story. I'm not the best person to do it, but I do know who should. And I think that's how we take EJ communities from just being, CBF didn't find Buckingham and every other organization doesn't find these things. Those communities are there and they're vibrant and willing. We're just able to help bring that story to the main stage. And I think that bringing communities up on the same level as the big greens and the advocacy organizations and everyone who automatically gets the microphone is how we make them more dependent and independent, and how we ensure that access is not just limited to those of us who are traditionally asked to give our opinion.
I'll just expand also that we had a program a couple months ago now that Taylor was on that was phenomenal about community lawyering and how that's a very different perspective than typical lawyering. And so I'll just note that, you know, if you're a community that's, I mean, if you're a lawyer that's looking to help a community litigation or non, please watch our CLE, and you get CLE credit on community lawyering, because it is different than your evaluative lawyering that you typically do in your firm. And you need to think about how to assist a community, particularly what Taylor was saying. You do not want to create a dependency on the lawyer. That's not the best situation here. You want to help a community build their capacity. Okay, so when you're a community lawyer, you're in there. Yes, a lot of it is you're listening, and really listening, but a lot of it also is just consulting and educating on aspects of the law, so that now they know the law and now they can make better decisions for themselves going forward. They don't need to call me about the law; they know it now, right? So this is a different approach than the typical evaluative lawyering, where you come in, you want me to come up with a good hard answer, and I give it to you, and then we do something hard, right? That is not what a community is going to need. So see it in a different way and approach it in a different way. You're facilitating, you're building capacity, and you're following their lead. And to Taylor's point, something that I really focus on in my practice, anytime that the community can speak for themselves, literally speak for themselves, they should. Now, if there is a moment when the community says, hey, Scott, lawyer, please, we need you to make this argument in front of this venue. Okay, good, you do it. That's what you're here for. Great. But that perspective needs to shift from the typical, like, I'm out front and I'm always going to be the one, you know, doing it. No, that's not the approach. That's not how you support communities most effectively in telling their story and being self-determined and being able to develop a future for themselves.
You know, along that line, we talked a bit about, and it just kind of goes hands in hand, the ELI pro bono clearinghouse that exists might also help in this manner. Yeah,
and so I'll just say I dropped the link in earlier, but I'll just say it also, eli.org/pro bono. Please head there. If you're a community and you're looking for legal support from pro bono environmental lawyers, you can post your matter there. There's a process to go through. If you're a lawyer who wants to support EJ communities, it's a perfect place for you to go. It'll tell you how to do it, how to register. And then you will be prompted to watch that CLE on community lawyering that I mentioned earlier for Taylor. That's a mandatory thing because all these communities really need lawyers to approach them from a community lawyering standpoint. But it's got dozens of matters that are currently open. The communities really need the legal support. An AM 100 law firm just took a matter on the last 48 hours. So hint, hint to all our lovely friends out there in big law, small law, medium law, join us and help support these communities.
Very good. Any other comments that you have for our two amazing panelists before we hang it up for today? Well, I mean, I'll just say I am excited. And especially because of people like Taylor who are out winning cases like this, and communities like Vincent's who are showing other communities how to do this. It's an exciting time. In 15 years of being an EJ lawyer, I've never had real victories until just recently. Everything else was like a moral win. And you find ways to sort of chip away at the big old block and it gets a little bit better. We're starting to get real wins. And that's very exciting. I wish I were a law student becoming a lawyer now, rather than 15 years ago of toil when the space was basically, nowhere, at least in the law and getting real purchase in results. And now we're achieving that. So it's an exciting time for students and an exciting time for EJ communities and exciting time for EJ lawyers. All right, well, I have to agree. And I loved the fact that
You went back on mute.
Oh my goodness. I was just saying to all, I just had to agree because one of the other delights from meeting with Taylor, Scott, and Vincent earlier was the fact that Taylor's window isn't as long as Scott's and Vincent's. So she's just got more hope behind all this because she's been, from day one working, on matters and seeing more, more real result in the litigation world. So thank you to everyone.
I will echo all of that. I just want to say thank you so much for our audience for joining us today and for your many thought-provoking questions. We hope you'll continue to watch the space in the years ahead. And I will also plug ELI's pro bono community and hope you can join that. And just a final huge thank you to our outstanding panelists today. We so appreciate your many contributions to today's program. Again, a special thank you to Latham and Watkins. We really appreciate all of your contributions to this amazing three-part series. And we hope to work with all of you in the near future. Thank you all so much. Please take care and stay safe. Thank you again, everybody.